Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon, Judge. We've met more than once, but I'm still Michael Sasson. And the protocol will be that each of the commissioners will introduce themselves. Commissioner Amanda Perry Carl is not here in person today because she is on the speakerphone. She'll participate remotely. After we do the introductions of the commissioners, you'll have 2, 3, 4 minutes, wherever you need, to make a brief opening statement, comments by yourself. I have about 20 minutes of Q&A. I have the unfortunate job of being the timekeeper, so I'm going to shut it off. And then after that, we'll give you another couple, 3 minutes to make any closing remarks you'd like to make, sir.
All right, sounds good.
We'll get started.
Good afternoon, Your Honor. Vincent Citro of the Law Offices of Horowitz and Citro.
Craig Dyer, Public Defender's Office, 7th Circuit.
Andy Gardos with Gray Robinson.
Michael Sasso of Sasso and Sasso, PA. I think she's got it on mute. We have Commissioner Amanda Perry Carl on the speakerphone.
And Brett Renton with Schatz and Bowen. Good afternoon, Your Honor.
Nice to see you, Your Honor. Keitra Brownlee, the Brownlee Law Firm.
David DeArmas, Criminal Price and DeArmas.
Your Honor, good to see you again. Scott Thomas with Burr and Forman.
All right, thanks. Great to see all of you again. And just by way of introduction, reintroduction, I'm Randy Rowe, Circuit Judge here in Volusia County. I want to thank you for inviting me back in again and looking over my materials. I saw most of you in December, and it's great to see you again. I hope I haven't worn out my welcome. but
We're happy to see you.
So I guess just by way of some background information, I've been a circuit judge for 14 years this coming December. Was appointed in 2005 by Governor Jeb Bush, and was subsequently elected and re-elected without opposition for full terms. I began in the courthouse just up the street here at City Island in Daytona Beach, and then later transferred over to the Volusia County Courthouse in Bland. Of course, I still, from time to time, cover dockets in both the City Island Courthouse and the Criminal Justice Center in Daytona Beach. By way of experience, I guess, I pretty much have experience in all of the various divisions in the circuit court. I've spent most of the time in the civil division. I'm currently on my 3rd tour of duty in the civil division. I presided for 5 years in a criminal felony division, a couple of years in a family law division. I still have some criminal matter that I preside over. A couple of things I don't think I've mentioned before. I do have 2, I call them specialty area assignments that I handle for all of Volusia County. In my division, I preside over all of the Jimmy Rice Act cases. You may all be familiar with that. That involves the involuntary civil commitment proceedings of sexually violent predators. And I like to say, lucky me, I have all of those cases for Volusia County. The way that works is I have one prosecutor and one public defender, and the 3 of us do all these cases. Usually it starts out with somebody who's serving a prison sentence and they're about to be released. If the state feels that that individual is a danger to society, they have the option under the Jimmy Rice Act to petition for an involuntary civil commitment. The defendant is entitled to a trial by jury, and I've presided over some of those. If the defendant is committed, they all go down to the Florida Civil Commitment Center down in Arcadia, DeSoto County, for treatment. And that's what it's all about. It's treatment. It's a lockdown facility. They're not free to leave, and they're supposed to do treatment down there. They're all entitled by statute to an annual review, so I do the annual reviews and various other motion hearings. And it's something that it's a regular, do this on a regular basis for all of the county. Another thing that I do in Volusia County, I handle all of the juror show cause contempt hearings. If you're summoned for jury duty and you refuse to show up, you have to come see me. So, and I do that for all of the judges for all, the whole county. I think it's a good process. I use it, and usually every other month we'll have about 50 people come in who, after a couple of reminders, just they aren't going to show up. And so I use it as a learning experience, teaching experience, and teaching them the importance of, why do we have juries? Why is that important? People's constitutional right to trial by jury. We talk about that, and then I give all of them an opportunity to come back and do it another time. I don't threaten anybody with, even though it is a contempt hearing, I don't threaten anybody with contempt or with jail. We give them all another opportunity to come back and serve, and I would say probably 99% of them do come back. However, there are some who just aren't going to do it, and we have to take up our time to have subsequent hearings and deal with it. One last specialty area that I used to do last year, you're probably familiar with the new law, the Risk Protection Act, I call it. Some people call it the red flag laws. Governor Scott signed it into law last year, which of course has to do with law enforcement petitioning to seize guns of people who have committed a criminal offense or threats with a gun and who may have a mental disorder. And so I handled those. I was the first judge in our circuit to preside over a risk protection petition hearing and to enter a risk protection order. It's my understanding I was one of the first judges in the state to do that. It was a brand new law. And then over time, the chief judge and I handled them, and now another division handles them, so just to even out the workload. One final thing I want to mention, which probably is the most important thing, and I've talked about that before, is my appellate experience, which is most relevant to why I'm here. In our circuit, circuit judges are randomly assigned appeals from the county court. Some circuits have appellate divisions or appellate panels. We randomly assign them to all the circuit judges. So for my past almost 14 years, I've handled appeals from county court. And in circuit civil, obviously, I also handle certiorari review of various administrative tribunals, city, county boards, state administrative agencies. I would say between all of those and the county court appeal, I probably handled around 100 or so of those type of matters. It's pretty much like any appeal. If they request oral argument, we give them oral argument, read all the briefs, and enter a ruling, and I try to get those out as quickly as I can. I have always tried to write something. I don't issue PCAs. I don't recall any just straight PCAs that I've issued. I feel strongly about explaining myself, explaining my ruling, so that the lawyers and the county judge will know what I was thinking and why I'm ruling that way. So I always try to write a written ruling, and in fact, I just did 2 of them over the last couple of weeks. While we were closed for the approaching hurricane, I used that time to sit at home and write an appellate opinion, which is probably kind of sad, really, but I did it. I didn't want to, kind of pathetic, you get a life, but I wanted to make productive use of that time, and so I knocked out one of the appellate opinions that I needed to do. So that's kind of a capsule summary. Other than the professional side, I still live in DeLand, married, 2 kids. One of them is getting married next year, and I have to find a way to pay for a very expensive wedding. So if anybody has any advice in that regard, I'll be glad to listen.
Elopement.
Yeah.
Pay a little money and just go. So I'll be happy to answer any questions.
Thank you, Judge.
Judge, I was assigned to vet you, and I've had that privilege, and I have to admit that as soon as the names came out on the list, even before I was assigned the vetting process, Jim Clayton gave me a call, and Judge Clayton was saying, don't forget, Randy Rowe. Most everybody I've talked to feels the same way. You're very strong on that. But one of the things that came up in the prior process was the fact that you were questioned on the amount of time it takes for you to render an order. Have you sped up the process, and if you have, what did you do to accomplish that?
I don't know that I've sped it up, I try to get them out as quickly as I can. I referenced the two appeals that I just did, and those went very quick. The one before last, I felt that I could have ruled on the briefs, but the attorneys both wanted an oral argument. So Judge Terry Perkins and I, he was the secondary judge, I was the primary, and we had an oral argument and asked a lot of questions. And then within a couple of weeks after that, I got the opinion out. I'm one of these people that I gotta have a clean desk when I leave at the end of every day. I can't stand leaving stuff behind. So I try to get everything signed before I leave every day. And with appeals, of course, those take a little longer because you got a lot of, usually big record review and briefs to read. But I try to get those out. The only thing that holds them up is giving the oral argument. And once that's done, I really do try to get them out, get an opinion out within 30 days, if possible. Yeah, I try to be quick about it.
Is there anything that has been published recently, or opinions published recently in the last 2 or 3 years that stick in your mind, something that jumps out that you find is extremely useful to you?
Florida Supreme Court, U.S. Supreme Court.
Doesn't matter where it comes from.
Yeah, one thing I've been waiting, now that we have a new majority on the Florida Supreme Court, I've been waiting for that Dahlberg ruling, and it's finally come. I've kind of been a little bit amused with what I call the Dahlberg-Fry tennis match. It seems to go back and forth. I remember listening to Professor Earhart in a lecture, and he just threw up his hand. I don't know what's going to, next week it'll be something different. So he didn't know where it was headed, but I felt like with Justice Kennedy's dissent previously, I knew that once things changed and he became Chief Justice, I had a feeling that we would have Dahlberg again, which I preferred. I mean, it's what most states use, the federal standard. And I guess as a selfish reason, I had to learn it, and I flushed everything about Fry, and I didn't have to relearn it. So I think that I was glad to see, and that's useful to me, to know that we're going to be sticking with Dahlberg. So that's one recent case that I was glad to see. There have been others, both Florida Supreme Court and U.S. Supreme Court. As you're probably familiar with, I'm anxiously awaiting the Florida Supreme Court's decision in that State versus Dwayne Owen case regarding the retroactive issue of the death sentences, because it directly affects 2 cases that I have. And I'm very anxious to see what they're going to do with that, so we'll know how to proceed with my 2 cases.
And we did actually put your name up once before. It did go up to the governor, right?
Yeah, 3 times before.
So the last time you went up there, how did you field the questioning that they provided to you?
The Governor Scott conducted phone interviews, and he called me, and we had a very nice conversation. He was very personable, and he kind of joked about his new job in Washington. So he asked me some good questions. They were the questions that I had heard. They were, in fact, I had attended a couple of his speeches. One was at the Federal Society banquet, and he told us, he said, "This is what I will ask if you come meet with me." And so he did ask those questions, and I thought I gave him good answers. So we had a nice talk. It was really enjoyable.
If you were sitting where we are sitting, what question would you ask an applicant for the 5th DCA?
Well, I know usually we're always asked about judicial philosophy, which certainly is important. I think I've been asked this every time, either here or at the governor's office, but people are interested in our position on PCAs, which I've addressed. contribute to the appellate court. And I would say research and writing skills and experience, but I would make every effort to actually write opinions. I can understand the importance of PCAs, but I will try to write opinions. So questions like that, I think, are important. Obviously, anything of concern in an applicant's application, you should ask about. I know that there's always a strong interest in judicial philosophy and following the law. I'm asked every time about statutory interpretation, which they should ask about. And actually, the ruling that I mentioned with Judge Perkins, I enjoyed writing that because the sole issue was about interpreting the statute, but the two sides were interpreting it different ways. And they wanted to talk about the absurd result if you interpret it this way versus that way. The county judge had found it ambiguous. I studied it, and I knew that my job would be, what's the clear, plain meaning of the text. Don't read between the lines, don't add anything. And it was not that difficult for me to do that, even though I could see how both sides were having a different interpretation. I broke down the statute, analyzed every word, part after the comma, and really, it was pretty easy to make the call as to what it says, and that was my ruling. I wrote the clear, plain meaning of the text says this, and I think that's what judges should do and not do anything beyond that. If I'm lucky enough to have the opportunity to go to Tallahassee, I'm certainly going to talk about that case. So I kind of enjoy writing it because actually there are no reported DCA or circuit opinions on that statute. So I was kind of glad for the opportunity to write on it. Maybe if it gets published, it will be helpful to somebody else. Anyway.
Should the rules of interpretation be different if the provision being interpreted is a constitutional provision? And then should they be different if that constitutional provision was proposed by citizen initiative?
I don't think it should be any different. I think, a judge should follow what the words on the page say. As far as citizens initiative, if the voters approve it, and I have to review it, I'm going to look at what it says, but I'm certainly also going to listen to both sides as far as what they think the intent was. I kind of had one opportunity, you don't see this a lot, but years ago I had one opportunity, and I think I wrote about it in the application, where it was a citizens initiative that the city was trying to keep off the ballot. I had to rule on that and study the wording, and ended up ruling that there was nothing unconstitutional about it and that it was on the ballot. So, but yeah, I think the same idea applies. You just have to look at the text and follow that.
If you do look at intent in the context of a citizen initiative, do you look at the intent of the drafter, or do you look at the intent of the citizens? And if you're looking at the intent of the citizens, how do you determine that?
Well, hopefully the drafter of it, hopefully that reflects the intent of the citizens who were promoting that. And I guess I would have to hear everything and try to decide, well, does this accurately reflect what everybody wanted and what they voted on? And I haven't had to do one of those yet, but I would look first at what the language says and try to determine the clear, plain meaning of the statute or the constitutional amendment or referendum or whatever it is.
So are you saying then, Your Honor, that after, say, you're trying to understand what either an amendment or a statute means, and the intent isn't clear from the plain language, so then what do you, if anything, resort to?
Well, it was like that opinion I just wrote, that the county judge thought it was an ambiguous statute. And of course, both sides are saying that, one side was looking at everything before the comma. Well, this is what it means. And the other side was looking at the part after the comma. Well, look at these words here. This is what this means. And so I want to hear what everybody says the intent is. And I know in that particular case, one side had referenced an impact study that was done on the bill. And there was language in there where they said, we think this is what it means. I didn't agree with that. Yeah, I want to listen to all that and then try to figure it out for myself. But the most important thing is, I think, what the text says. And it wasn't, initially I thought, oh, this is hard. How am I going to figure this out? But after I studied it and looked at the words and what do the words mean, and then I was able to find, the attorneys didn't find it, but I found some case law that helped me out a lot. I think it was the first DCA case that was approved by the Florida Supreme Court that explained 3 words that had been used in very similar statutes that were in this statute. And I'm like, well, there it is. So I feel like that I interpreted it the way the legislature intended and what it says in the statute.
Thank you.
But it can be tricky.
Mhm. I'm sure.
Anybody else? Okay. It's very nice to see you, Judge. That'll be the end of the Q&A, and
Okay.
give you an opportunity to make any closing remarks.
Oh, well, thanks. Wow, I was prepared for a really tough one.
We used them up before.
Well, I just want to thank everybody for looking over all the materials. And I know this is a difficult job. You're taking time away from your practice to have to do this and listen to a lot of boring people say the same thing probably. But it is a very important service that you're doing. I appreciate it. Glad you had me in again. I've enjoyed the process every time, and I tell everybody that, because everybody wants to know as soon as they get back to the courthouse, how was it, what did they ask you? I always tell them that everybody is very nice and pleasant, and that you treat everybody very well here. And so I don't really want to bore you with anything else about myself, especially since you've heard it before, but I do appreciate the opportunity to get to come in, talk to you again. Yes, I'll leave it at that.
It's good to see you, Judge.
Thank you for coming.
Thanks so much.
Have a good night. There's all those doors back there. It's the one there. Yeah.